Constitutional law expert advocate Michael Osborne joins us now for more. Very good evening to you. Thank you so much for speaking to us. Let's just first start with the parameters which informed this investigation by the public protector. We spoke about the executive ethics code, members code, but what else was the public protector leaning on to arrive at this conclusion?
Well, it's good evening to you. It's largely, as you say, the executive ethics code. So the parameters of the report are relatively narrow because the public protector said that there were at the time and still are parallel investigations by the Reserve Bank and by SARS. And she commented at one point that SARS would be in the best position to answer some of the detailed financial questions that are at stake. But in terms of the executive ethics code, there's no conflict of interest because it could not be said in the ordinary definition of the term employment that the president was employed by the close corporation that runs Phala Phala. That's the first thing. Secondly, he could not be said to have abused his office by failing to report the theft, because in fact he did report the theft to General Ruud, the head of the VIP protection unit, and he was entitled to assume that General Ruud would take the appropriate next step in terms of upward reporting. So it's a rather narrow finding. Not that the president is off the hook, so to speak. It's a preliminary report, and the parties implicated now have 10 days to make comment. So in principle, one could see a different final report. But for the moment, one has a rather narrow semi-vindication of the president, strictly in terms of the ethics code.
And I wonder, as you mentioned, the South African Revenue Service, it's released its own statement, including releasing the tax statement, personal tax statement of the president. But there's the South African Reserve Bank, which has instituted an investigation. We don't know the outcome of that yet. Could that change the findings, the outcome of the public protector's report, even outside of the comments that are due in the next 10 days?
Yes, in principle it could. If either SARS or SARB came out with damning findings involving concealment of foreign exchange transactions, failure to make appropriate tax reporting, then yes, in principle, the public protector would be able to revisit her findings. But it's been made very clear that for the moment, the public protector is hands off with respect to those two parallel investigations.
We mentioned earlier on in the introduction that the public protector's report specifically points to the fact that the president's actions cannot be found to be in conflict, that is his financial interests vis-a-vis his official obligations. What is used to judge that? And I'm looking at what is there within the law, but also from discretionary perspective. Many observers have said that it renders him vulnerable as a president to conduct businesses in this manner, that what may seem innocent may actually have legs that influence him in public office.
Well, yes, that's crucial. You asked me on what basis the acting public protector would have come to this conclusion. And that's relatively simple. There's a rather clear understanding, both in the common law and in terms of labour legislation, about what it means to be an employee. Now, by no definition of what it means to be an employee that I know about, which would be excluded under the executive code, under no reasonable definition is a person who owns an interest in a trust that in turn owns a close corporation, that in turn owns a ranch. By no definition of the word employee does that render you, as trustee, an employee of one of the many indirect holdings. So I think that's pretty clear, and it's difficult to get away from that. Now, you asked me whether there might be perhaps broader conflict of interest concerns outside of the strict legal definition of employee. Now, I think that is something that would need to be determined on a case-by-case basis. There's nothing that emerges from this report that suggests that in this particular instance, the president was personally involving himself in decisions made by the persons who run the day-to-day business of the close corporation, which, as the report points out, is a major organization. It's got, I think, something like 44 full-time employers, and they're the people who run the show. And until someone can come forward with a plausible allegation that the president ad hoc intervened in the affairs of the close corporation, that's more or less all that can be said.
Just in terms of General Ruud, whom you mentioned earlier on, the public protector finding, the acting public protector finding that he should face consequences for what she termed abuse of power, if you could explain that. And there was also a finding around Ndili Msoki, the acting spokesperson for the Office of the Public Protector, saying also that Bejani Chauke traveled to Namibia to meet with President Hein Geingob with a police escort, and that her office determined that was approved by the former National Police Commissioner Kathles Tolle. But what would be the consequences of that? Does that not suggest conspiracy, and conspiracy on behalf of whom? Because surely he would not have acted alone for his own behalf. Well,
the report is rather skimpy, I would say, on Mr. Chauke's involvement. I would imagine that opposition parties and the complainants would be demanding to know more about Mr. Chauke's involvement. And it could be that there'll be representations and submissions, and a final version of the report will tell us a little more. About General Ruud, however, there is a fair amount of information. And that is General Ruud, of course, being head of the VIP wing of the South African police services. He was asked by the president, apparently, to investigate. He did conduct his own, I think the term used is the term used in the report is an off-the-record investigation. No docket was opened. And essentially an investigation was conducted, apparently outside of the purview of the president. General Ruud said that he reported the matter upwards in the hierarchy to a senior member of the police force, but who has died in interim and therefore could not be interviewed. So we left with some rather troubling gaps in the record. I think that it will be easy for critics to, as already happened, to say that the president essentially outsourced the investigative function, asked Ruud to conduct an investigation, and kind of washed his hands of it. That will be the accusation. Whether that's justified, I don't know.
Advocate Osborne, before we run out of time, a very important point has been made that this report seems contrary to what the panel led by former Chief Justice Sandile Ngcobo found, and that is the president may have a prima facie case to answer. But one of the reasons that panel said it was non-committal was because of the lack of evidence. You said from the onset about the findings of this preliminary report by the acting public protector is that it looked at this from a very narrow perspective. So is it possible that it would have then reached this conclusion because of a lack of evidence, which the panel said they couldn't get? It was not forthcoming from some of the people who made the allegations, but including those who were involved.
Yes, I think that's a valid concern. I think it must also be understood, though, that the Section 89 inquiry, which was chaired by the former Chief Justice, that had a completely different ambit to the Public Protector's investigation, in the sense that that was what you might call a desktop investigation. The Chief Justice and his colleagues did not go out and interview people, request documents, conduct detailed factual investigations. The Chief Justice, the former Chief Justice, made perfectly clear that it was not his function at the time to report to Parliament on the basis of his own or the committee's own investigation. Now, this report from the Public Protector, even though it's preliminary, does state that it relied upon extensive interviews with all of those involved. And so there's no necessary contradiction at all between an early desktop report, which didn't interview witnesses, and a subsequent report, albeit preliminary, which did apparently conduct its own investigation.
Different mandates, therefore they'd come to different conclusions. That's basically what you're saying. Thank you so much for your time. Thank you so much for your time and insights. Much appreciated. Constitutional law expert, advocate Michael Osborne, speaking to us about that report, the outcome thereof by the acting public protector, which of course has 10 days for those whom have been implicated or who are interested parties to respond to.